Good morning and welcome to a session of oral arguments before the 5th District Court of Appeal. We have 3 civil cases on the docket this morning. And so with that, we proceed. I'd first like to introduce the panel. On my right is Judge Dorfinger, and on my left is Judge Vincent Torpy. The fact that one's on the right, one's on the left has absolutely nothing to do with your judicial philosophy, I assure you. The first case that I have on the docket, Pennington case. Is counsel ready to proceed? Yes, sir.
May it please the court.
Hold on. How much time? Do you want to reserve some time?
Yes, I'd like to reserve 5 minutes for both, sir.
You got it. And you may begin, sir.
May it please the court, my name is Brian Solomon. I represent Pennington Associates, the appellant in this case. This case arose out of a construction project up in Bellevue.
I had Mr. Sasso down on my docket. Are you?
Yeah, he's the senior partner of the firm.
Okay, so he sent you up here to handle the oral argument?
Yeah, actually, I've handled the case all the way through at trial and on the appeal, but he was listed first on the signature block. This project...
If you win it, he gets the credit. And
absolutely. Absolutely.
You get the picture.
So I'm going to try to make him proud of that. But this arose out of a construction project up in Bellevue, Florida. And the appellee, Mr. Evans, was the owner of the dirt.
Let me ask you this. What is it that you're trying to acquire by foreclosure at this point? What?
Yeah,
there's a real property is a bundle of rights, they say. Tell me what's sticking in the bundle you're trying to acquire.
Well, the claim of lien, back up. The notice of commencement describes an address which relates to a parcel of property called parcel ID.
Yeah, I got all that. Just get to the heart of my question.
Yeah,
at the end of the day, the sheriff is going to sell something, and there's going to be people that are going to bid on it. What is it that he's going to sell, in your view?
Parcel ID 38796, as described in the tax.
The entire parcel?
The entire parcel, except for the portion that has already been sold in foreclosure, which was the least portion of the...
Okay, well, that's what I'm trying to focus in on. What's left?
Yeah, everything but that little piece.
Okay. Now, what the tenant, who was the 360 corporation?
360 Networks, yes, sir.
All right. What was their interest in the parcel that you're trying to foreclose?
Well, they had a leasehold interest in the one piece of property.
I know, that's gone, right? That's already been foreclosed and sold to somebody else.
That is correct, Your Honor. But as part of their lease, they had an agreement with Mr. Evans to improve other portions of the leased property by bringing pipes across the property to the leased property.
All right, but I'm trying to understand what their interest is, their legal interest was in that other parcel. I know they had some sort of a sewer pipe, right?
Yes, sir.
Through there, okay. How would you describe their legal interest?
Well, pursuant to their agreement their lease agreement with ORA Evans, they had the right to bring those properties across here to further improve not only their piece of property, but the entire piece of property.
But wasn't it that they had the right to run a sewer line? Is there something more to it than that?
No, that was it.
Okay, is that like an easement then?
Actually, I think there was an easement that was issued on this or provided on this case or on that piece of property. But the plans and specs of everything that was agreed to upon by 360 Networks and Mr. Evans provided for these improvements to be made.
They didn't have the right to build a building on the parcel, right?
No, they did not. And
they didn't have a leasehold interest in the parcel, right?
Not outside of the leased premises, no, sir.
Okay, so they had the right, some sort of a right, to run a sewer pipe connecting their property to the sewer system, right?
That's correct, yes, sir.
Okay, and is that what legal interest is that? Is it an express easement? Is it an implied easement? Is it a fee? I mean, I'm trying to identify what the legal interest is.
Well, I think there was either an express or implied easement. There was an easement that was executed, right. But I think the testimony was at trial that the property, that it didn't quite follow what the express easement was.
All right, now, if it's an easement, okay, now, my recollection of easement law is that there's a dominant and a servient estate that relates to an easement. What would be the dominant estate?
I'm assuming that the dominant would be the parcel owned by Mr. Evans.
Okay, wouldn't it be the leasehold interest? In other words, the sewer system, the sewer pipe benefits the leasehold interest, right?
Correct.
That 360 had?
Correct.
And now, what's the effect of that when that leasehold interest in favor of 360 is extinguished?
Well,
Do they still have the right to use the sewer pipe when they no longer own the leasehold interest that the sewer pipe services?
well, I think once the lease extinguishes, then they wouldn't have the right anymore.
All right.
But
Aren't you trying to get the right, aren't you trying to foreclose on a right that has really been extinguished because the tenant lost the leasehold interest and therefore lost the right to use the sewer pipe?
no, I don't think so, because, and this is the reason why, Mr. Evans also would, when we were putting down the sewer pipe, he directed where it would go because he wanted to be able to tie that into other buildings that he might build on the other properties. So that pipe was not going to just benefit the leasehold estate, but there was some testimony about Mr. Evans, or that Mr. Evans wanted to put it in a certain location so that he could also put other buildings.
Or are you saying that you have the right to foreclose the fee interest in the dirt that where that pipe lays?
Yes, because under 71310, Mr. Evans had the right to exclude all of his property if he followed the guidelines of 71310 by recording the lease for a short form of the lease, but he did not do that. So he subjected, it's our position that he's subjected parcel of property because it's an undivided, contiguous piece of property.
When you filed your notice of commencement,
Actually, the owner filed that, if I may correct you.
okay, when the owner filed the notice of commencement and you filed your notice to owner and the claims of lien, was the parcel that you're attempting to foreclose on included in any of those descriptions?
Yeah, there was a couple of different descriptions. It gave an address, it gave a plat book, and then it also enclosed what was at the time an illegible piece of paper attached to the notice of commencement. Mr. Evans testified that, number one, that the address referred to parcel 38796, which was an undivided parcel. He had leased portions of it, but as far as a parcel, it had not been subdivided. And so that address specifically referred to parcel 38796.
But there were other properties on that had different addresses on that same parcel, were there not?
Yeah, there were other buildings that had
Well, how could a surveyor then go out there and locate that property on the ground just within a street address?
Well, like I said, I don't know.
Okay.
Well, your notice to owner that you filed
Yes, sir.
described it and gave it a specific address, which I think the parties agreed was the 360 Networks building, and described it as the 360 Networks building, in fact. Isn't that correct?
I believe that's correct. But the notice of commencement also referred to plat book A and B, which is also that parcel 38796.
Counsel, there's a long line of cases that says that the lease has to require the improvements, or that the improvements be the PIT, P-I-T-H, of the lease, is what the cases say, before the contractor could subject the lessor's interest to a construction lien.
Yes, sir.
I've read this lease over, and I don't think it requires, certainly gives permission, but it doesn't require any construction on that, nor is it the PIT of the lease.
Well, Your Honor, that was discussed in a motion for partial summary judgment below, and it was ruled upon that it was the PIT of the lease, and then it wasn't really raised again, and it wasn't raised by anybody. But I think under Frenchie's,
It was ruled upon that it was or was not.
that it was a PIT of the lease, that it required it.
Well, but my understanding in looking at the lease provision says it's understood that the tenant, 360 Networks, has the right to install, maintain, et cetera, within the premises, poles, wires, and pipes. And then it goes on to say that in connection with the tenants' efforts to secure services from utility companies, the landlord agrees to execute reasonable easement agreements, giving the utility companies the right to install pipes, etc. That seems to be a far cry from requiring them to make those improvements. It simply says that we're going to allow those easements to be created. So I guess that follows up on Judge Torpy's question is, even if your position is well taken, how could you subject the entire parcel to a foreclosure when the lease at best gave the right to an easement to run a pipe across?
Well, I think it hinges on Mr. Evans' testimony, number one, where, well, actually, I don't remember if it was Mr. Evans that was testifying, but I think it was Mr. Simpson who was our superintendent on the job, who told him they were going to run the pipes in a certain direction. Mr. Evans asked him to move them in a different area so that he could still put buildings there and tie into them. I think there's testimony that Mr. Evans actually knew that they were going to be putting and making improvements outside of the leased premises. He was shown the blueprints, which clearly show that there were improvements outside of the leased premises. So I think all of that together puts him on notice that our contract required that. Also, I'd like to point out that the notice of commencement was not recorded by the owner until after we even started on improvements. And that's the owner's responsibility. But so we were bound by our contract to make the improvements, which clearly required us to do these premises. And in my brief, I talk about, you know, the improvements, and it's kind of like the Palm Beach Mall case. You know, if you're improving a mall, an interior of a mall in a small space, and there's a construction lien on it, it just doesn't make any sense that when you foreclose on that construction lien, if that's all that's described, that you only get this 10 by 10 space inside the center of the mall. It's improved the entire property if it's been incorporated into the property, and therefore you have the right to foreclose on the entire thing. Same way with if you had an existing home and somebody wanted to put in a pool. If the pool contractor doesn't get paid, they don't get just the pool. They get the property that they've improved. And it's our position that all of the property that all the work that we did improved the entire parcel of property, especially since Mr. Evans made specific directions of where to lay the pipe.
If that's the case, Counsel, then how did this subcontractor who foreclosed get only the leased premises?
Because that was all that he was seeking to foreclose on. That was what he sought in his complaint. That's what he foreclosed upon. And our complaint is we've always sought to foreclose on the entire parcel of property.
Well, but I thought that you sought to foreclose only the tenant's interest.
Well, we sought to foreclose based upon our improvements on the real property.
So, but when you foreclose someone's interest in the property. Did you seek to foreclose the owner's fee interest in the property that was not leased to the tenant?
Yes.
I'm just having a difference. So if you're successful, the buyer at the foreclosure sale is going to own the parcel of property that was adjacent to the premises that were leased to the tenant.
Correct. And then
that's your theory.
And then we would foreclose on the remainder of it.
Well, no, I'm talking about your foreclosure.
Yeah, we would
foreclosure culminates in a sheriff's sale.
Correct.
And a buyer buys something. That you're saying that the buyer at the foreclosure sale is going to walk away with a sheriff's deed to the parcel that is adjacent to where the leasehold was.
Yes, sir.
Let me come back to your citation. You think that the Palm Beach Mall case supports your position here, but my reading of that case was that although apparently, as I understand that case, the mall leased one of these little mobile kiosks or gave the right to a tenant to put in one of these little mobile kiosks in the middle of the mall.
Yes.
And it was the electrical connection that was made into the mall property. The trial court said that electrical connection was enough to create an improvement on the property, such that a lien could be had, but my understanding of the holding on appeal was that the appellate court reversed that and said, no can do. So I guess my question really relates to two things. Number one, it seems like the holding of the case is adverse to the position that you just argued. And number two, and I think more importantly, there really wasn't any discussion in that case about what constituted the mall property. Nobody focused on whether when the mall property was the little 10 by 10 square that this guy had, or whether it was the entire Palm Beach Mall. So I'm curious why you think that case supports your position.
Well, the case was reversed because the court determined that the kiosk itself, being a removable item, did not constitute a permanent improvement.
So how did the appellate court ever even get to the question of whether or not, if it had been, they could have gotten a foreclosure on the entire mall? I mean, it seems to me that that question just never even comes up in the case.
Well, I don't think it does to that extent, and unfortunately, that's the only case that I could find in Florida jurisprudence on this issue. Thank you.
Good morning, Your Honors. I'm John Moxley, and I represent Mr. ORA Evans, who's the appellee. And Mr. Evans owned a tract of land in Bellevue, Florida. Part of it was improved with two buildings on the south side, on the south end of it, approximately an acre. The north 1.49 acres was leased to 360 Networks. 360 Networks was a telecommunications company. They were going to put in a building there to house switching gear and electronic fixtures. The lease had attached to it a description, a legal description, which only included...
What do you say about his statement that there had been some ruling by the trial judge that the construction of the sewer was the pith of the lease? What was that ruling about?
Your Honor, I don't recall that the court ruled on that matter. There was no summary judgment issued in regard to that. However, it was my opinion in reading it, whether right or wrong, was that it was the pith of the lease. Otherwise, it would not have existed. The whole circumstance of the lease was that. Unfortunately, the lease did not include the protective language that would allow Mr. Evans to keep his property from being liened.
Counsel, let me ask you, along with Judge Torpey's question here, let's assume that we conclude that on a de novo review that it was not the pith of the lease, it was not required by the lease. Can we affirm the trial judge on that basis?
Well, I'm not sure that you can.
Even though it wasn't raised as an issue?
It wasn't raised as an issue. Certainly we don't have it on appeal. I did not raise it on appeal. And so I'm not sure that the court could do that, but I would have to leave that to them.
Well, there's a tips and coachman rule that says even if the court arrives at the right decision for the wrong reasons, although I don't know that the reasons are necessary, I mean, he just didn't rule on it.
Yes. I'd have to defer to the court on that.
Do you agree with the opposing counsel that the notice of commencement that was recorded by your client contained a legal description that was broad enough to include the parcel that we're talking about?
No, I do not agree with that, Your Honor, because if you look at the notice of commencement, the notice of commencement does state an address. It does state lots 12 or 13 or something of that nature, but it also indicates see attached, and that attachment is the specific legal description of the leased premises. Now, the claims of lien that followed that up referred, in every case, referred to the notice of commencement, and the legal description is described therein. They did not set out, not a single time on one of the three claims of lien did the appellate set out a separate legal description attached to its claim of lien. It always referred to the notice of commencement.
So the legal that was used in the notice of commencement had attached to it, or the notice of commencement had attached to it a legal description that specifically described, I guess by meets and bounds, the portion of the property that was leased to 360?
Correct, Your Honor.
Did that description include any description of the utility easements or any place where the pipes were supposed to go?
No, it did not. It did not.
So to what extent do you agree or disagree with counsel that Mr. Evans' testimony was that he intended to benefit from the sewer pipe that was put across the property by being able to tie into it for other improvements on the remaining parcel?
My recollection of that was that he wanted that within 10 feet of the western boundary of the property along that street there, so that he could use the property if he wanted to put another building in there. He did not want a pipe running down through the middle of his property, but he didn't say anything about tying into it from his from any future improvements.
Your recollection of the testimony was he just didn't want it to interfere with future development of the property as opposed to tying in as an enhancement to the property?
Correct, Your Honor.
If there was testimony, and I guess we have to kind of dig through the record for this, but if there was testimony that he expressed some intention of tying into that sewer line for future development on the property, would that constitute an improvement in your mind or a benefit to his remaining property that would arguably subject it to a lien?
Well, it could certainly be classed as an improvement in that regard, but I don't know that it would ripen into a lien, because I still think that under the law, if you describe the property that you're liening, that's all you can get. I don't know of anything in our mechanics lien law that allows you to go outside of that lien. And he certainly had no contract with Mr. Evans, and actually had no right to assume that Mr. Evans would agree to a different contract than he had with 360 Networks. So I don't think that
had the time to file a lien on the affected property expired when the plaintiff below amended the complaint to include the remainder of Mr. Evans' property? In other words, were they still within their lien period, or had the lien period run?
Now, the lien was filed. No, it was not. It was outside the 90 days. The second amended claim of lien was outside the 90 days.
And that was the first time that the remainder of the parcel was described in the lien?
No, it didn't change anything in that regard. It was the second amended complaint that added paragraphs 11 and 12, or 10 and 11, which described the new piece of property that which was the 1 acre with the 2 rental units on it. That was the second amended complaint that described this new piece of property.
And hadn't the statute of limitations run on that time, at that time?
It had run at that point, Your Honor.
But you're saying that the claim, no version of the claim of lien ever described the property where the sewer line is?
That is correct. Other than that, Your Honor, I believe that in terms of the easement, first of all, an easement has to comply with Florida law, which requires it to be witnessed by 2 witnesses, just as a deed. And
You can have an implied easement, though.
You could have an implied easement, but I don't think you have an implied easement here. At the best, I would think you would have a license. And again, if you look at the testimony of Mr. Evans, his conversation was not with 360 Networks, and it was not with Pennington Construction. It was with an official with the city of Bellevue, and they discussed where this sewer line would be placed. And of course, he said 10 feet, and the testimony shows that it was not close to 10 feet.
Was any easement given to Bellevue, or was there anything in writing stating that you've got a right to run this property or run this pipe along this particular line?
Not in that regard, and the easement that they are referring to, that was brought up at the trial, and I don't believe an easement was admitted into evidence, but it was discussed.
There's nothing in the record to indicate it.
No, that easement was not even to this piece of property. There was an easement given by Mr. Evans, but it was an entirely different piece of property several blocks away.
Okay. Thank you, Counsel.
Thank you.
I'd just like to make a couple of points in regards to the statute of limitations. The claim of lien has never, basically the description on the claim of lien has been the same the entire time. What we did in the second amended complaint was merely...
But what does it describe? Counsel says it doesn't describe the parcel that you're seeking to foreclose on.
Well, it's our position that the address and the plat book refers to parcel 38796, which is an undivided piece of property.
Counsel, what's the current state of the law on using a street address as a legal description? There's been a lot of cases over the years that I haven't researched it lately. What's the current?
Well,
Can you use a valid legal description as simply a street address?
I don't think that that's a valid legal description, but it does describe a parcel of property, or it refers to a parcel of property, an address is connected to it, and that's the way we got into it. Because what I failed to mention, or may have mentioned, is the original notice of commencement that was filed, number one, was filed after we began our work, and number two, what was filed was illegible. But regardless, the plat book and the address all connect to 38796. Mr. Evans testified that that was all part of that same parcel.
Well, irrespective of its legibility,
Yes, sir.
Am I correct that your notice to owner and subsequent liens referred back to the legal that was contained in that notice of commencement? So apparently it was legible enough for you guys to deal with at the time.
It referred back to the notice of commencement in its entirety.
Okay. Now is it correct, as opposing counsel says, that attached to that general description was then a specific meets and bounds description of the leased premises, which did not include the parcel upon which you're seeking foreclosure?
That's correct.
Okay.
That's undisputed.
All right. So tell me now, when all the claims of lien are done, the various iterations of the claims of lien, and the complaint is filed, when is the first time that the parcel that you're seeking foreclosure on now becomes the subject of a dispute?
Well, I think from the entire point in time, we were suing to foreclose on the property that was contained in the claim of lien, which had three different descriptions. It had the attached legal description, it had the plat book that it referred to, and it had the street address. In the second amended complaint, what we did is we clarified what our interpretation of the claim of lien, what it attached to. But that doesn't change
the fact that the remaining parcel had been foreclosed on by someone else was just serendipitous. That didn't have anything to do with.
No, that had something to do with it. No question about that, Your Honor. But it was always our intention from the beginning to foreclose on the whole thing, because if you looked at just the leased premises, what was on that leased premises wouldn't have paid for the $512,000 of improvements that had been made. So we would always have the intention to foreclose on the whole thing. We did not specifically state that in our complaint. We only referred to what the claim of lien. But the claim of lien descriptions never changed. And so
the claim of lien description, I guess, really attempts to describe it in three ways. A street address, and apparently the parties agree that the street address describes the building that you all were constructing, as opposed to the other buildings. You agree with that?
That's correct. No doubt.
It includes a reference to a plat book and page, which apparently includes the entire parcel.
Yes, sir.
And then it includes a meets and bounds description that includes only the parcel that the 360 Networks was apparently dealing with.
That's correct.
So there's three potential legal descriptions there.
Correct. And it is our position, once again, if I go back to what if you look at Mr. Evans' entire parcel property got improved. He knew, he admitted in his testimony that he knew that the pipes were going to be run across the property.
Do you recall anything, or can you point to anything in the record? There's apparently some disagreement between the parties on their recollection of the evidence.
If you would look, I think the transcript is around pages 320 through 330 is an area where Mr. Simpson was discussing that. I just looked at it briefly, and that was the section that I was thinking about. So, I appreciate it. Appreciate your time. Thank you, Judge.
Thank you, Counsel.
Thank you, Counsel.
We're going to